Hello, everyone. Thanks for tuning in. This is Ingo Dachwitz. I'm a communications and media scholar and journalist from Berlin. I work as a reporter and editor for Netzpolitik.org, a German blog about technology, politics, and digital rights. It is my task today to give you a short introduction to the European approach to the personal data economy. And I think it's great to do this as an online conference, as much as I was looking forward to meeting you all in Jakarta, and how it's like a true digital discourse, so to say, due to unforeseen events. I hope you're all well and healthy, and I'm looking forward to the discussion on Saturday, May 2nd. Okay, but now let's take a look at the regulation on the protection of natural persons with regard to the processing of personal data and on the free movement of such data. Very long, or in short, the EU General Data Protection Regulation, or even shorter, the GDPR. And I think it's a great time for this debate since we are heading towards the anniversary of this law. But not as many might think the second birthday of GDPR. In fact, we have to look back at nearly 10 years, nearly a decade of history already, GDPR, since it was in the making for approximately 5 years, from 2011 until 2016. And then the law was adopted in May 2016 and was followed by a transition period of full 2 years. And in May 2018, GDPR really entered into force. And as I mentioned, I can only, this will only be a brief introduction. It can only be a brief introduction since the GDPR really is a law of superlatives, really. It consists of 99 articles with hundreds of paragraphs and is accompanied by 173 recitals, so really big law. And the making of GDPR was framed as the EU's biggest lobbying battle by some. And even its strongest critics have to admit that the GDPR has set a standard for the regulation of personal data that is a reference point for other regulation in other countries, from India to the USA. So for the sake of this quick guide, I choose to boil down this big law to 3 concepts and categories that help understand it. It's the 3 R's of GDPR, how I call it: rights, rules, and risks. Okay, but before we take a closer look at those 3 concepts, we have to start with some general remarks. So first of all, what are the objectives of GDPR? Here we have to mention 2 different aims. First of all, the protection of fundamental rights and freedoms of EU citizens. According to the EU Charter of Fundamental Rights, data protection is in itself a fundamental right for European citizens. In Article 8, it says, everyone has the right to the protection of personal data concerning him or her. But data protection also is characterized as a fundamental right that subsequently protects other rights as well. You cannot freely develop your own opinion, personality, live your religious beliefs really, or your political beliefs if you have to suspect to be monitored at every time possible. But GDPR also has a second important objective, and this is an economic objective. The law is an important piece of the EU's project to create a European digital single market. This means one common sphere where digital services and goods and also data can circulate. To achieve those 2 goals, the GDPR had to replace an old data protection directive that was in place since 1995. So GDPR did not come from nothing. In fact, in some parts, it is not too different from this old directive from 1995. But this data protection directive had 2 major shortcomings. It was adopted very differently by each EU member state. So there was no harmonized law and no data single market for the European Union. And secondly, the directive was widely ignored because it didn't give the data protection authorities, the DPAs, the possibilities to enforce it properly with sanctions and fine. So we could see a huge enforcement gap on data protection, although there was laws in place already. Okay, so what does GDPR regulate? What's the scope? GDPR deals with the electronic processing of personal data that happens inside the EU or is happening to data subjects inside the EU. Data subjects is the name for, it's the wording of GDPR for individuals which data is being processed. So this is one very crucial aspect. It doesn't matter where a company or any other data controller is registered. For if it's operate with personal data in the EU market, then it is bound to GDPR, at least as long this data is not anonymized. Whatever anonymization means here, I will come back to this later, is a question of ongoing debate. And the general rule of GDPR for this personal data is that it must not be processed unless there is a specific legal basis for it. So no processing of personal data unless there is a legal basis. The GDPR entails 6 legal grounds on which processing of personal data is legal. The most famous is the informed and freely given consent of the data subject. There's a common misunderstanding that this was the only legal basis that is established by general data protection regulations, so that whenever you want to do data processing, collect data, analyze data, work with personal data, you had to have the subjects really given and informed consent. But this is not true. Actually, there's 6 different legal bases that are laid down in the GDPR on which data controllers can rely on. Other legal grounds are that there is a need for that the data is needed for the performance of a contract or to comply with the legal obligation, or that it is needed to protect the vital interests of the data subject or for the performance of a task carried out in the public interest. And the 6th legal basis is that is of very much high practical importance, that the controller has a so-called legitimate interest in the processing of this personal data and has come to the conclusion that his or her interest outweighs the individual's, the data subject's interest of data protection. And as you can guess, we could spend another 30 minutes alone speaking about this interesting aspect that the data controller has the right to act only on the legitimate interest and his personal conclusion that the legitimate interest of his business, for example, outweighs the individual's interest of data protection. But for the sake of the overview, we will just leave it here with the legal basis and jump to the first of our 3 R's, the rights of data subjects. As you can see, there's a long list of rights data subjects or individuals are granted by the General Data Protection Regulation. And the first one, and maybe the most important, is the right to be informed. So whenever there's data processing happening, the data subjects have the right to be informed about it, and not only have to be informed about the data processing that is happening, but what also happens to the data, which rights an individual has concerning this data, who's responsible for the data processing, and so forth. Closely related to this is the right to access. So data subjects, individuals have the right to ask data processors, data controllers, to access the data they have about them. And also closely related to this is the right to data portability. So data subjects not only have the right to get to know what data controllers have about them, but they can also ask them to hand out this data in a machine readable format. With this was there's to this article 20 is bound the hope that this might lead to some form of competition among, for example, platforms. If it was possible for me to take all my data from Facebook, for example, and transfer it to another social media company, it might make it easier for me to leave Facebook behind. although the practice shows that this doesn't work as easy. For example, if you don't have any competition in the field of social media, there's no social media platform that works in the same way. So I can ask for data portability, but I have nowhere to go to. Okay, then in Article 16, there's the right to rectification. So if I stumble across mistakes in my data, for example, after I used my right to access the data, I have a right for my data to be corrected. I have a right to erasure, which has become famous as the right to be forgotten. So I can ask data processors to delete all my data, to forget all my data. Obviously, unless they have to do this unless there's a reason why they need to keep it. So you can't, for example, ask the telephone company to delete all your data because they needed, for example, some of that data for billing purposes. Then there's the right to restriction of processing and right to object. So me as a data subject, I can go to the data controller and ask them to stop certain forms of processing, or I can object the processing in general. So when I have given my consent, I can take it back later on. And then there's the very much interesting right not to be subject to a decision based solely on automated processing. What this means in practice, we don't know yet very much. I will come back to this later. But at least in the law, there is this right not to be subject to a decision based solely on automated data processing. And then maybe this is the most important right. Every EU citizen, every data subject has the right to lodge a complaint with the DPA, with the Data Protection Authority. So if a data controller, for example, doesn't comply with my rights, if they don't give proper access, for example, or if I suspect that I don't delete or correct my data, although I've asked for that, I have the possibility to lodge a complaint with the Data Protection Authority. Okay, let's come to the second R of GDPR, the rules for data controllers. But the first one is an easy one. As I just said, data controllers have to act on the ground of legal basis as they are laid down in Article 6. Then furthermore, there's key principles of data protection that data controllers have to comply with. For example, there's the purpose limitation as a key principle, or data minimization or transparency. So purpose limitation is one of the really key principles that the data processor must not use data collected for one purpose, and maybe I granted my permission for one purpose, to any other reason, basically, so that's a purpose limitation. Obviously, data controllers have to comply with the rights of data subjects. And then there's an interesting formulation in Article 24 that data controllers have to implement appropriate technical and organizational measures of data protection. So data protection under the GDPR doesn't only mean being legally compliant, but is understood as some sort of process. So if I'm a data controller and I want to use persons' data, I have to install appropriate technical and organizational measures to take care that data protection requirements are met. For example, I have to limit the access in my company. Who has the access to the data, or I have to encrypt data so that not everybody can use it, for example. So there's a huge range of appropriate technical and organizational measures. Whatever this, what exactly this formulation means is not laid out in GDPR. So there's huge debate about this, but the important aspect here is really under GDPR, data protection is not only about legal compliance, but it's also about the technical and the organizational processes, the measurements that have been taken in some sort of data protection management. Then there's a very interesting and new innovative Article 25 that asks data controllers for data protection by design and by default. So technical systems have to be technically designed, and process-wise have to be designed in a manner that they have like data protection at their core. And data protection by default means that whenever there's options for data protection, they have to be at the most protective level from the beginning. So me as an individual, when I log into a platform, when I make an account at a platform, for example, I don't have to go to the data protection options to the menu, but I can rely on the fact that by default, those options are at the highest level to protect my data. In practice, we see that this is not happening at all, and this is very hard to bring to life. More on that later on. And then there's another very important rule for the data controllers. They have to maintain records of processing activities. So they have to have a repository of all the personal data processing that is happening inside their operations. For reasons of documentations, they have to be able to show this to the data protection authorities, to the DPA, in case. And also data controllers are obliged to secure the data processing's state of the art, as it is said. And last point here, in general, data controllers have to designate an internal data protection officer. So this is a person that is in charge of, looking at the internal processes of data protection, and has to kind of advise, like an internal advisor that is looking at the processes that are happening inside the company, that gets educated on this. So there's a requirement for companies. It's different from which size on, but many companies have to do this. Okay, and then now let's look at the last of the 3 R's, the topic of risk. GDPR entails a somewhat dynamic approach, the so-called risk-based approach to data protection. For example, there's a definition of data categories, special data categories that are so sensitive, high-risk categories like health data that entails information about race, politics, religion, sexuality, biometric data, and so forth, that is stronger protected than than the rest of the data. For example, by the fact that it is that it is needed, that consent is needed here, and other legal grounds do not work, for example. Then there's another aspect for risk, kind of dynamic aspect plays a role in the data protection regulation, and that's the obligatory notification of data breaches to the data protection authorities and to the data subjects in case they mean high risk for them. And then very interesting aspect in Article 35 and 36, data controllers are obliged to do a data protection impact assessment before they start data processing. So whenever I want to set up a new database, a new data system, for example, or a system technology using data, I have to do a data protection impact assessment. And this is a criteria for all the data processing that is happening. In case you, the first step here is that you look at the risk. Does my planned data processing mean a risk to the fundamental rights and freedom of the data subjects, then if I expect a higher risk, then I have to do a proper obligatory data protection impact assessment. And if after this impact assessment, I come to the conclusion that although I installed several organizational and technical measures, I still come to a high risk for the rights and freedoms of the data subjects, I have to consult the data protection authority first. So this is one of the more innovative aspects of general data protection regulation, since it is making possible some sort of more dynamic look at data protection issues. But there's a second dimension to the risk aspect I want to point out, and then we're already done with looking at the law, and we'll have a look at the practice. So the second dimension of this risk, of the third R, the risk aspect, is that GDPR means an highly increased risks for violators of that data protection regulation. I said in the beginning that that the former data protection directive from 1995 was suffering an enforcement gap due to several reasons. The GDPR kind of changes this game and increases the risk for violators to be first to get detected, due to the fact that the independent data protection authorities are better equipped now, and to the fact that data subjects have the right to file complaints in every member state, and also to be represented by NGOs in the field of data protection. So me as an individual, I can say, okay, I can be represented by an NGO to take care of my rights, to file complaints on my behalf. And really, for me, as if I'm on holidays, for example, or if I'm an expat living in another European country, now with GDPR, I don't have to wonder if I can file a complaint here, or I do have to do it in another country, maybe the country where the data processor I suspect of wrongdoing is registered, or my home country, but I can do it in every member state actually. And there's not only an increased risk that data protection violations get detected, but there's also an increased financial risk that is bound to those violations of GDPR, since GDPR makes it possible for data protection authorities to sanction fines of up to 20 million euros or 4% of the annual worldwide turnover of a company. Whichever is higher. So this really is a game changer. This really makes, and we can see that already, this really makes the data protection an issue that is in companies, for example, that is not only a compliance but a financial issue. Please keep in mind, as I said, and I really want to stress this here, this was only a very brief overview of some of the major articles and mechanisms of the general data protection regulation. Really, for every aspect I mentioned, we could spend another 20 or 30 minutes more discussing exceptions, for example, from those rules and how those articles come to life in practical day-to-day data protection reality. And this is why, for the last minutes of this talk, I also want to take a look at GDPR in practice. And the first thing to mention here is that although GDPR was aiming at fully harmonized data protection law for for the whole European Union, we see some differences in the adoption by different member states. Still, GDPR itself entails more than 60 opening clauses for member states, and even beyond those, some of the member states opted for their own interpretation of GDPR. So the overall picture, I'd say, is still coherent, but in details, there are substantial differences between several countries. The country of Austria, for example, decided that the data protection authorities cannot fine public bodies such as ministries and governmental agencies. Secondly, we can say that most of the fears that accompanied the days when GDPR entered into force, they did not materialize. In May 2018, when shortly before GDPR entered into force, there was a huge public debate and outcry about GDPR because, well, everyone who had a blog or website suddenly realized that now they had to deal with data protection as well. And in many cases, they kind of failed to fulfill the requirements before because they just had integrated, for example, Google Analytics without further thoughts of informing their website users about this. So we could see here that the European Union and especially the member state governments failed to inform the public about what would be happening with the data protection regulation and foremost to give functional advice on how to get compliant. In combination with the fear-mongering that happened about the fines that would now be possible, this led to a major backlash in the public opinion on data protection, since some little bloggers also kind of felt the threat of 20 million, of fines of 20 million euros, for example. But since data protection authorities chose to use sanctions proportionately and did not start to fine bloggers with millions, the situation is kind of calmed down. But we still have to say, in some parts of the public, especially among companies, GDPR is still unpopular, and there's still ongoing debate and critique. The third aspect I want to mention here is that nearly 4 years after GDPR was resolved in May 2016, compliance is still a work in progress. And it's very much putting it gently here. I obviously don't have concrete numbers on this, but from what we hear from data protection authorities is that most data processors, when they investigate companies, they find at least some flaws in data protection. So in most cases so far, the DPAs are still very tolerant here and conservative in fining companies and other data controllers, but this might change in the near future. Fourth aspect to mention of the practice here is that there are dozens and hundreds of lawsuits pending on how to interpret aspects of GDPR correctly. I guess there's not a single article and paragraph for which there are not different readings. So the data protection authorities constantly release working papers and recommendations for orientation, but we have to admit that it will take years until there's a legal certainty for the main questions around the GDPR. Yeah, but what we can say with certainty is that we see increased numbers of complaints to and decisions by the data protection authorities. So the DPAs are not very good in reporting those numbers in a coherent manner. But for example, in the first year of GDPR, we saw nearly 200,000 complaints by European citizens to data protection authorities. We also saw some major fines for violations. For example, British Airways has to pay a fine of 205 million euros for a major security breach, the biggest fine under GDPR so far. But dozens of the very interesting cases concerning GAFA, Google, Apple, Facebook, Microsoft, Amazon, they're still open. So actually, we wait for those interesting and bigger cases to be closed and to be decided upon. The only one I know of is that the French Data Protection Authority fined Google with 50 million euros in 2019. I think it was 19 for insufficient user information. But yeah, there's a whole lot of cases open at the data protection authorities concerning Google and Facebook mainly, but also the others of the big five. And then one last learning from the practice so far, we can see that in the data economy, individual choice is often an illusion, as I already pointed to in the beginning, if there's only one social media company that kind of dictates the contracts and kind of dictates the situation users have to accept, it doesn't matter if I have the right to consent. If I want to take part, for example, in digital social life these days, I kind of have to consent to, for example, the WhatsApp terms and conditions or Facebook terms and conditions or Instagram terms and conditions, which all belong to the company Facebook. And maybe in the situation, in the Corona situation now, we also see this. Many people might experience this. If you want to take part in video calls, for example, many people don't actually, although in the GDPR kind of grants them the choice, they don't really have a choice to choose another operator, another infrastructure for video conferences, especially if their employer, for example, decides to use one. I don't want to mention one here, don't want to open those debates, but just as an example. Okay, so this leads us to the open questions and to-dos. What's still to do with GDPR? And as you can see, the list is long, and yeah, that's not everything. So we can still see there's an enforcement gap. So many data protection authorities still lack the sufficient resources to kind of fulfill their duties correctly. Also, we can see that there's a problem with coherent decision-making by the oversight bodies across European borders. So for every country, there still is one data protection authority, and they kind of cooperate, they kind of communicate with each other, and there's a mechanism under GDPR how they come to common conclusions, but this is still very shaky, I'd say, and still, there still has to be established a good way to come to coherent decision-making among those different oversight bodies. Then we have to say there's no substantial progress made in the field of standardization and certification. Both this would be possible with the general data protection regulations, and there was a big hope that, for example, standardization would help to make data protection easier, but there's close to no progress in this field yet. Also to be established yet is a competitive market for data protection friendly technologies and data protection management tools. So there was this huge hope that with GDPR, there would be established a market for data protection friendly technologies or data protection management tools that help you comply with data protection requirements. But actually, this didn't happen yet, or not in a substantial way, at least. Then, as I mentioned, there's many open questions on GDPR interpretation. One that I want to highlight here is the question where to draw the line between personal data and anonymized data. So this might be one of the most important questions, also related to the question of standardization. So when do we call data that was further that was former personal data, how can we anonymize it, and in which state do we accept it as anonymization, since research shows that much of the data, it's not enough just to cut off some identifiers. Much of the data that is so-called anonymized can be re-identified by researchers. So next open question actually is, does the GDPR entail solutions for issues around big data, algorithmic decision-making, and data brokers? So far, we don't know yet. The risk-based approach might entail or might be a possibility to resolve the issues around big data and algorithmic decision-making, because if a data processor has to lay down in a data protection impact assessment, has to lay down the risks and what he does to prevent the risks that come with the data processing he's planning. This might be a possibility to have a look in the black box that data protection, that big data and algorithmic decision making kind of mean. But so far, GDPR still has to deliver on this. Then there's a huge debate about innovative forms of data governance, for example, data trusts. So how, for example, can I as an individual decide to give up the rights for my data if I want to do that, and hand it over to a trusted body, a trustee, data trustee, that for me kind of could deal with platforms, for example. Well, then obviously there's a question how to tackle the dominance of GAFAM, Google, Apple, Facebook, Amazon, Microsoft. Beyond the questions of data protection, we kind of see that data protection is not enough to deal with those. There's the e-privacy regulation pending, a lex specialis that was supposed to clarify GDPR on the protection of communications data. This is due to extensive lobbying by the data industry, still in the making, and there's no, it's not seen. There's no end in sight, actually. And well, just on a formal notice, the EU Commission is planning to publish a GDPR evaluation report in 2020. Okay, and with this, I'm coming to the conclusion. As you can see, GDPR is very much of a political compromise. As I said, there was huge lobbying going on. So, and actually, both sides, data protection activists and the data industry, they're both not fully, or maybe not at all, happy with the result of general data protection regulation, which kind of shows that it is a compromise. This means really, although it has the image of Europe being the data protection stronghold, or GDPR being some sort of data fortress, GDPR really does not prohibit the use of personal data in general, but kind of establishes a regime of rules and rights and oversight over personal data. Having this said, GDPR is maybe best categorized as a liberal or neoliberal approach to the data economy. So it has very little, actually no red lines inside. Everything would be possible, for example, if an individual would give consent to it. Very much emphasis on individual choice. And on the contrary, there's also no positive vision in it how to use personal data, for example, for the greater good, for civil solidarity, for democracy. So it's neither red lines nor positive visions, but very much of a liberal, neoliberal approach. GDPR, I think that was clear, has not delivered what it promised yet, and it still needs and awaits proper adoption and enforcement. So, my last point here is, and with that I'm closing this quick guide to the European approach to data protection regulation, is that GDPR, rather than a fixed solution for the personal data economy, it has to be seen as a starting point, really. There's much work to be done concerning adoption and enforcement, and the questions of interpretation. From my perspective, it cannot take long until we have to accompany the GDPR with further specific laws like e-privacy law, for example, or we have to change certain aspects. GDPR is a good starting point for the debate compared with what we have in the rest of the world, I'd say, but it's a starting point, and the debate has to go on. Thanks for your attention so far. I'm looking very much forward to hear more about the Southeastern Asian and especially the Indonesian perspective on data protection, and look very much forward to the debate. Yeah.